Good evening and welcome to another meeting of the Statistical Society of Australia. This is the Victorian branch. I'm Lyle Gurran, I'm the president of the local branch, and it's my very great pleasure to welcome John Henstridge here tonight. I'll give him a full introduction in a moment, but I always forget the administrative business, so what I'm going to do is ask people to put their name and their organisation on this sheet as we hand it round. Can you do that? Thank you. And for those of you attending the dinner afterwards, if you don't know where the venue is, just contact myself or one of the people in the front row on the branch council and we'll give you a hand. So it is my very great pleasure to welcome John Henstridge. He's come from Perth today. He's already spent half an hour talking to the branch council about matters from the national body, and we appreciate his time there as well. He's the Managing Director of Data Analysis Australia. He is a man with some strong opinions, but also someone who has a considered and thoughtful position on many things as well. On a personal note, I've known John since I was an undergraduate at the University of Western Australia. I've had many discussions with him, and I think it would be fair to say that his views and his advice have very much coloured my view of the profession over the years. So, John, I invite you to come up, talk to us about being an expert, and then we'll take some questions later on. Thank you.
Okay, can you hear me with this microphone? Okay, good. Thank you. Thank you, Lyle, for that introduction. And yes, I do remember you as a very raw young undergraduate. You haven't changed a bit. Okay. Just see if we can get rid of this little bit. I should just. So maybe that will all just behave itself now. Okay, all right. The title I chose for tonight is The Statistician as an Expert. And then the subtitle was The Truth, the Whole Truth, and I originally wrote And Nothing But Statistics, but then I thought that no, it's very important to work out the way that statistics works with other areas. So this is really the truth, the whole truth, and statistics, and the way statistics works with lots of other things. My background for this, Lyle gave it a brief description, but for those of you who don't know, I've been working as a commercial consultant for an embarrassing number of years. Get to the stage where you don't count the years, you count the decades. So I think it's, 3 decades roughly. And part of the work that I've been doing, especially in the last 10 years, has been in legal matters. And what I wanted to talk about is the experiences I've had in that area as a statistician working in legal matters, and what it says about statistics and what it says to us as statisticians. So, is this going to work? Yes. This was going to work. This is technology for you. It just wasn't talking to. Okay, fair enough. It wasn't looking at the program. The focus must have been on the toolbar at the bottom. Okay. All right. So I'm going to start by talking a bit about what an expert is, then talk about the role of the expert in court. I'm going to use a number of examples of that. Now, all of these examples are my personal examples. I'm not going to use from anybody else, although I know that there are a number of other statisticians who have worked in legal matters. Like I know, for example, that Ian Gordon here has, and when he and I were on opposite sides. So, there. But the message I want to get out of this is what this tells us, as all of us as statisticians. So, the definition of an expert. There are a number of definitions of experts. Most of them aren't very complimentary. So it's an ordinary fellow from another town, that's Mark Twain. It is a man 50 miles from home with a briefcase. There are other things like in that same theme. You know, an expert is somebody who, when you ask them the time, asks if he can borrow your watch first. Niels Bohr made a very good comment, which is it's a person who has made every possible mistake in their own field, and hence has learnt from that. The public has got a very dim view of experts. This is one of my favourite cartoons, which I came across. It's not quite experts in the context I'll be talking about it today, but another form of experts. But it indicates the public's view of experts in many cases. Is there anything more adorable than the smiling face of a newborn, or expert you could say, with fresh-picked science to order? And that is a major issue that we do have. A definition from a dictionary, this is just extracted from a few dictionaries. It's a person who with special skill and knowledge in some particular field, specialist and authority. Probably the word I would like to emphasise most tonight is that word authority, although we'll also talk about how you can be an authority in the area of statistics. The law has got a very special view of what an expert is, because in legal matters, they call upon experts all the time. Lawyers themselves will bring in expert lawyers for handling certain aspects of the law. And in fact, the way in which the legal process handle non-legal experts is actually very similar to the way they handle legal experts. So the experts are there to help the court in a technical matter. It can be from any area, but they must have the relevant expertise. The role there is to help the court, and I'll come back to that on a number of occasions. Even though the role is to help the court, the expert is usually retained by one of the parties. So when you get to court, you've usually got a situation where two sides are arguing it over some matter. It might be a criminal matter where one side is the prosecution, the other side is the defence. More frequently for the sort of work that I do, it's a civil matter, so one side is a plaintiff, the other side is the defendant. And the plaintiff is actually trying to generally make the other side do something, often involving money. And as an expert, usually I get retained by one of the parties. So being retained actually means being paid by that party. And in some respects, that's the limit of what that party does, because at the end of the day, as an expert, you're there to help the court. There is a provision for experts to be appointed directly by the court, where the judge can say, I need an expert on this. But judges hate doing that, because any decision that a judge makes can be appealed. One side might say, I didn't like the expert you chose, and that could be a grounds for an appeal. So therefore, they tend to only get appointed if both sides agree, and if people can't agree about the substantive matter in the legal case, they're unlikely to agree about appointing an expert. However, having said that, even though the experts are appointed by one side or the other, or retained by one side or the other, their role is to help the court with unbiased advice, even if that advice is detrimental to the person who's paying them. And that has been most definitely the case in some of my experience. My first experience with this was very interesting. It was when I had first set up my company, and I think I had one employee at the time. So I was a very small organisation. And I was networking amongst some other consulting groups, non-statistical consulting groups. And one of them said, they've got a job where I might be the appropriate person. Would I like to come and talk to some lawyers? And then I did go and talk to some lawyers who were in Perth from a Sydney office for quite a big legal argument. The discussion was a very simple one in one sense. The argument was all about a survey. The actual legal case was two insurance companies arguing with each other about whether one could enter the market in Western Australia. This might sound like a silly argument. In fact, it was. The court eventually said it was a silly argument. But the one that we wanted to move in was being held up by the existing company there, who said, oh, the names are too similar, the logos are too similar. The public will be confused. So therefore, we should just keep our monopoly, effectively. Now, that was a good argument in some respects. And actually, the plaintiff, the people who were bringing this matter to try to stop GIO Australia from entering Western Australia, used a survey to actually demonstrate this confusion in the public's mind. And I was hired by the defendant, which was GIO Australia, to provide some advice just about this survey evidence. There's a whole lot of other matters in the case. This case eventually took up 10 weeks of court time in the Federal Court of Australia. 10 weeks of court time, you think in terms of, this was 20 years ago, think in terms of, in today's money, about $30,000 a day for each side arguing over this. So this is big money. The plaintiffs had actually organised a survey to be carried out. And they'd gone to a good market research company to do this survey. And in fact, despite what I'll be saying shortly, subsequent to this matter, I actually directed a lot of clients of mine to this market research company because for some of the stuff they did, they were very good. If you wanted certain types of work done, they were the right place to go to. They had been asked to carry out this survey where, and to ask people about whether they were, if they were presented with these two logos, whether they thought they were similar or not, things like that. Whether the two names of the organisations, whether they were similar. Okay, it's a pretty standard sort of market research type of survey. I've described it as being 1990 vintage, which is roughly when this was carried out. And in those days, it was quite common for these surveys to be carried out face-to-face. So there'll be an interviewer starting off at some point in the suburbs and going from house to house with some protocol as to how they would move from one house to the next. There were experienced interviewers, they'd show cards, they could show people and everything like that. This was interesting from a legal point of view because this is one of the very first cases in Australia where a survey was presented in court. And there was this big argument, legal argument, about whether it could be presented. You know, was something like a survey ever going to be considered as valid evidence in court? From a legal purist point of view, this was seen as just being hearsay. In legal terms, hearsay is when you're not actually, you're just reporting what somebody else said there, so it's second-hand knowledge. So in a sense, a survey is all second-hand knowledge. So there was a real issue as to whether this would be presented or not. And there were arguments, there were QCs flown in from Sydney just to actually argue for one day that this should not be heard at all, in which case my work would have been somewhat curtailed. That argument fell flat. The judge in this matter, by the way, was Robert French, who is now Chief Justice of Australia. And he muttered words to the effect of, well, I will consider this later on, which means he's ignoring it. But that meant they had to put together quite an amazing evidence trail to get this thing in court. The person who designed the survey had to put in an affidavit saying this is how he did it. The person who drew the sample, which in this case was putting pins into a map effectively in some random process to get starting points for the survey, for the clusters, had to say how he did that. That was an affidavit. The person who actually, each interviewer had to sort of put in an affidavit saying, I conducted these interviews, and they were attached as attachments. It meant there was a pile about that high, much higher than that, of legal documents for this, with every single survey questionnaire being produced there as part of this. All the way through. The data entry people, the person who checked the data entry work, everything like that. So it was really quite interesting that this was required just to get something that to us is very ordinary into court. I'm sure that many of you would think that this would have been a good requirement for some of the data that you have seen yourselves. The scepticism shown by the court was actually probably very sensible. How did I approach this work? Well, I was allowed full access to all of this because as an expert, I am there to help the court, so I am given the ability to do that properly. That meant that I could see all these statements, all the affidavits, all the background information. I could get the data files that were provided to me. The questionnaires, if I needed to actually look at the raw data questionnaires, that was eventually provided for me. Okay, there were confidentiality issues, so there were little stick-on notes put across the things where they had addresses or anything like that, anything identifiable. And I wasn't allowed to look under those there. So all of that was correspondence. There was, quite an amazing amount of work going through it. And this was then followed by weeks of work in court itself. What were some of the statistical issues there? Well, one of the interesting ones for this, and this actually affects a lot of market research surveys, was that this was a cluster survey. And each cluster had a separate interviewer there. So it was a valid question to ask, well, what was the sampling efficiency? All the analysis was done as if this was 800 independent people, but it was actually a cluster survey. So the actual effective sample size turned out to be somewhat less. And it was interesting that part of that difference in effective sample size, some of that inefficiency came through not just because the clusters were physically in different parts of Perth, and those were, so you're getting a lot of variation in that sense, but so variation between clusters, but not much variation within the clusters there. But interviewers, the interviewer effect was aliased with that. So the actual effective sample size was somewhat less. I can't remember the exact figure, but it was enough to actually cast some doubt over this. There were also lots of other issues of with a survey like this. And again, I had to call upon my experience in running surveys, which, to be honest, wasn't massive at that stage, but I actually had run several and could actually work out what some of the issues were. Okay, there was non-response to the survey. That's always an issue in surveys. That was actually 25 years ago, that was far less of an issue than it is now. People were much more friendly those days. Interviewers were always making mistakes. Interviewers still make mistakes. That hasn't changed at all. They omit things and stuff like that. There are problems with coding frames. These are all just mechanics of running a survey. There are problems with questionnaire design where questions turn out to be ambiguous. And some of the questions turn out to be quite leading in some cases. And some questions are just absolutely irrelevant. You wonder why on earth this was asked. As a statistician involved in this, these are all issues I had to consider. As I said, this was the first proper legal case I was involved in, and it was a bit of an experience going into court for this. As I said earlier on, the role of the expert is to service the court, not their client, and that means they should not be under any constraints. If they ask the question, they've got to answer it honestly, even if it's to the detriment of their client. That means that they shouldn't be told what to say. These days, there are actually some quite strong practice rules covering this. 25 years ago, it was all just understood, but never written down anywhere. These days, there are practice notes saying about this. So it says today, for the Federal Court of Australia, that, well, basically what I've got up there, they've got to function for the court, not for the client. It also says things like, if required, as an expert, you've got to be prepared to go into conference with the experts on the other side, without lawyers. And in going into that, if there's a point that you agree on professionally, you should say you agree. You should not be held back in any way at all from agreeing. However, before you go to court, usually there's a prepared written statement. This depends a bit upon the practice of the lawyers involved as to how detailed that is. And the role in court is then very often just to present that written statement. You sort of realise that the function of a court hearing in a civil matter, in fact even in a criminal matter as well, is just the process of assembling evidence. That's all it's doing. There's a lot of protocol about assembling evidence. Again, you often wonder if in the scientific or research worlds that could be done better than it is. So there is something to be learnt there. So the first step is usually presenting that in the form of a written statement, and then that written statement or any other evidence, verbal evidence you give, can then be tested. And that means cross-examined. Cross-examination can be a bit of a painful experience. For my very first case, I was actually very lucky that the night before I had to give evidence, the person who in the same case had given evidence just before me rang me up and said, "John, just a few hints, just from my experience." Okay. He was allowed to talk to me at that stage. He couldn't talk to me earlier on. And he just gave me a few hints, one of which was, for example, that you don't ever have to answer a question if you don't know what the question is. Just ask for clarity there, or say how you understand the question. You don't have to answer it really quickly. And even if a barrister does say to you, "Dr. Henstridge, just answer yes or no," you don't have to say yes or no if neither of those is the appropriate answer. Cross-examination is a real skill, and some lawyers are very good at it, and good meaning they can be really horrible in this situation. Horrible to the person being cross-examined. I must admit that I had a very easy run on my very first go. I was lucky. If I'd had the experience of one of my later cases as my first, I probably would have never done it again. I must admit that. But the first case, it was interesting. The cross-examining counsel was Darryl Williams, who subsequently became Federal Attorney General, by the way, under the first cabinet of John Howard. He was very much an old-school gentleman, and he opened up his cross-examination by saying, Your Honour, to the judge, this will only take a short while because I will demonstrate that Dr. Henstridge has got no relevant experience here. And then he actually went to my CV, which was there. He said, "Okay, your first paper, what was that about?" And I had to say, "Well, that was signal processing for seismic arrays." It was the second paper, it was something on statistical computing. And then went to about 3 or 4 down and said, would I be right to say, Dr. Henstridge, that you've really had no experience on surveys whatsoever, and none of these papers are all relevant to that? And I said, well, no, paper this, and this are about surveys. This other work I've done there. And then he sort of had to back off. So the first tactic was just to get rid of the expert. That was then followed by a day and a half of cross-examination. A day and a half of answering questions and not being allowed to talk to anybody else about it during all that time. So you really feel alone there. So that's why it is ideal, and this often happens these days just from experience and you know how to do it, if the original written statement you can do is just accepted. People take it. But that does happen sometimes. So cross-examination can sometimes be short and simple. Darryl Williams with me in my first go tried to make it short and simple. There. Usually what they're trying to do is just to create enough doubt about things. Sometimes it can be really gruesome, however. In my first case, I'd got a relatively light cross-examination, that was a day and a half. One of the experts on the other side, the market researcher who had carried out the survey, he was cross-examined non-stop for 4 days. Every day, the results of his cross-examination were appearing. So the next day, his results of cross-examination would appear on the West Australian. Not the front page, but in there. By the end of his week, I think his business had halved in size. He was really pulled to pieces so much. And he didn't speak to me for many, many years. Because all the way through that cross-examination, he could see me sitting in the back of the courtroom there, passing up notes to the barrister who was cross-examining him, saying, which was suggestions about questions he should be asked. He does talk to me these days. But as I said, even straight after this case, I would often recommend him to my clients if they had a certain types of market research problems to do. He was definitely the best. Maybe I'll skip over this one because I've already covered it. Yeah. What are some of the issues for a statistician in this? In fact, I'll come back to this issue, this thing about how there's a lot to be learnt by statisticians in this. The first thing, of course, is that as an expert in a court, you're the only statistician there, typically. Or there might be a statistician for the other side who is in the background as well. But typically, you're the only expert in your area there. And that means you've got to explain even things which to us are absolutely automatic and obvious. You don't quite have to explain that 2 + 2 is equal to 4, but anything more complicated than that is difficult for lawyers. You have to focus on... Are there any lawyers in here? It would be my normal practice to insult somebody in the audience. I don't think I've done it so far. But, there's an issue of focusing upon what matters. And in a legal case, lawyers are actually very, very good at narrowing on details. So that for this particular case, it was quite a simple thing. Can they trust the survey? Or, to express it in legal terms, what weight should they attach to the survey? Okay, the legal people on the defendant's side that I was working for, they were trying to get the whole survey thrown out. But they never really expected that to happen, but they were trying to actually say, well, to lower the trust that the judge might have in this survey. And in doing that, there was a limit to how much technical detail could ever be expressed. The final thing here is that in doing work like this, the lawyers generally don't like experts. They don't like experts because experts will say things that are unexpected. And the experts will say it with some authority. Whereas lawyers actually like people who are going to say, like to always know what witnesses are going to be saying. So that it's a funny role there. This very first case raised for me some interesting questions which I've been trying to answer ever since. And one of the key ones here is, how do you translate from this statistician's world of inference into a court? And I say that because I know that when I taught in university decades ago, I would often use sort of the criminal trial situation of beyond a reasonable doubt as the analogue that is used for describing hypothesis testing, classical hypothesis testing, beyond a reasonable doubt there. Well, for a start, most legal matters are not based upon that. And even when they say they are, they're not really. It's a strange amalgam of logic that is going on there. And you start to realize that the lawyers are actually all the time trying to make inferences. They're working in this world. They're experts at it. Their ways of handling it are very different from ours, but they talk in terms of words all the time. Often words with very imprecise meanings, but they're very precise the way they talk with these words with imprecise meanings. If that sounds paradoxical, but it's just a different culture there. And you can start to get used to it after a while. But what it does mean is that you've got to be a little bit careful about just presenting what you might think of as a statistician as being a standard inference model. Because the courts don't work that way. So, they will talk in many cases of the balance of the probabilities, but they will still make comments that, well, but still the plaintiff has got the onus of making their case. Now, the first statement says that both sides are equal, in a sense, purely, which is the more likely of that. to be right, but the plaintiff, the one who is making the case, has actually got an extra responsibility for doing this properly. It's a funny one. My next project came out of that with the same barrister. This is a very, very different one. The West Australians in the audience might recognise this fellow. Yes? Laurie Connell, that's right. Well, it says so up there. But, yes, okay. That's good. Even students from UWA can read. And this was an interesting one because, again, one of these calls from the barrister saying, you know, I've got an interesting case I'd like to talk to you about. And I go in there and discover he's the barrister defending Laurie Connell. Now, for people who are not familiar with West Australian culture, Laurie Connell was a wonderfully corrupt businessman in Western Australia. It was said to him that he did not have an honest bone in his body. He simply could not do things without doing them dishonestly. He would rig horse races. He would defraud the government of hundreds of millions of dollars. He had a bank which was really sort of a money laundering exercise and everything like that. He was a wonderful guy. You know, a real character, shall we say. There. And he was being tried, in this case, for, of all things, rigging a horse race. Now, I've actually had rigged several horse races over the years, but this is one where it's a bit more blatant than many, where it actually, clearly he had bribed the jockey to fall off the horse. So it was quite a public thing. His lawyers had this wonderful idea of saying that he couldn't get a fair trial in Western Australia because it'd be impossible to choose a jury where there wasn't at least somebody who had preconceived ideas that he was guilty. So therefore they should just adjourn his trial indefinitely, which means to hold it at all. This sounded a bit like a perfectly reasonable argument because I thought he was guilty. How do we actually handle this in court? Well, it was an interesting matter. We actually said, well, we should actually survey people who were potential jurors, not people who were called up for jury duty, but people who could be called up for jury duty. We should survey them and do this in a way that was, in a survey that would then stand up in court. So the previous case was I was demolishing a survey, and that was a survey that should not have stood up in court. Here we had to carry out a survey that would stand up in court. And this actually meant a small survey, so you could keep it under control. It didn't actually have to be very large because we had guessed that the number of people, the proportion of the population who really thought that Laurie Connell was guilty would be sufficiently high that you didn't need a very large survey to actually prove this. That turned out to be right. We wanted to ask some very, very simple questions of the right people. The right people meant that we had to check up that they were not people who were ineligible for being in a jury. So we had to ask them, have you committed a serious criminal offence? Or done something just as bad, such as being a lawyer or a member of parliament, which exclude people from juries, and various other things. There. We had to ask them what they thought about Laurie Connell, and in this context, so that we didn't actually have the survey focusing too much upon just one individual, we actually had a bit of a rogues gallery we were asking people about, and Western Australia at that time was well endowed with people of this type. So Alan Bond was another one, and there's a few others there we could do as well, so that we could actually put together this court so it would put this survey together so it would stand up in court. So I used to describe it as a Rolls-Royce survey. I won't go into all the details, but with all the tracking that we did in terms of the procedures, where we not only briefed the interviewers, we did a trial of briefing the interviewers and threw away the interviewers we used for the trial so we could get the briefing right, even down to things like that. So they were not contaminated in any way. We changed the colour of the pens every hour on the hour in the telephone room where we were doing all of this. so that we could actually know when things were written down. Things like that. It was everything. It was Rolls-Royce. It was then actually presented in court. I knew it was being taken seriously a few days before, when the then Director of Public Prosecutions said to me, when I met him down at Pelican Point Sea Scouts, there, Perth is a small place, he was bringing his daughter down to see if she wanted to join up the adventurers there, and I was one of the leaders. He said, you know, John, your report's causing us some interest there, and they brought in a special counsel to cross-examine me on it. And the cross-examination went on for about 2 hours and eventually the judge said, Mr. whatever his name was, are you sure you're getting anywhere? Mr. So-and-so said, I don't think so, Your Honour. So that was enough for the day. Two things came out of that at the end. One was, following this, I was going down in the lift, and just by chance I was sharing it just with Laurie Connell. And I muttered to my breath, that bloody barrister was getting under my skin. And this nice Laurie Connell looked at me with this wonderful understanding look on his face and said, yeah, I know what you mean. I suddenly understood why he was so successful as being a con man and everything like that. He was a wonderful guy. He paid his statistician, he didn't pay his lawyer out of that. And the judge made it all irrelevant because the judge simply said, I will instruct the jurors to ignore any preconceived ideas they might have, and they will obey me. It was all pointless, except maybe it delayed his trial by 6 months. This was an interesting thing here, and this is an issue that I had to face, therefore, for this, choosing a client. Well, I didn't choose Laurie Connell. And when I came into those lawyers' chambers, and I suddenly realised the client is Laurie Connell, I had to think, do I actually work on the defence of somebody who I think is guilty? I never said that to him, by the way. And then I thought, well, yes, I have to, because if I don't, then he can't get a fair trial. You know, our justice system says somebody should get a fair trial, and then if they're found to be guilty, then it's quite clear that they're guilty. If somebody's defence is fettered in some way, then it's not fair. So I actually adopted from that time on a very simple rule. It's the same rule that barristers apply in legal cases. If somebody comes to me for help, if I've got the relevant expertise so I can help them, and I'm available to do the work, there's no conflict of interest, and they can pay, then I will take the work. In my mind, I must take on the work of that cases. So I've never refused a case because I don't like the people. And in my view on this is that you can't pick if you start picking sides, then you're no longer the unbiased expert that a court demands. So you might be surprised with some of the clients I've had subsequently. So we've done a lot of surveys over the years. I won't go into the fine details of these ones, but they're great fun sometimes. Like beer marketing. Imagine a survey going around all that beer there. It was a terrible survey. At least I said it was terrible in court. There was a fantastic survey we did of potential customers for a copyright tribunal case. These are customers of pay TV, or potential customers of pay TV. And given that we were on the side that was actually against the pay TV providers, and therefore not being no cooperation, how do we actually find these people? Well, I designed a sampling scheme that actually, how would I put it? We almost brought down Telstra's website, finding out, where can you get cable internet connections? Where can you get cable internet connections? Making so many inquiries of that we actually found out where the cable went. all through Australia. Then we used that for our sampling process. We got darn good sampling. Various other ones that we've done over the years. One of them I want to mention there is the Human Rights Commission. That's the one where I was cross-examined for 4 days. I felt quite sick at the end of it. That's the only way I can describe it. It was a gruesome matter. Why did it only go on for 4 days? Because the barristers on the other side, who were very, very, very well funded, were, 2 QCs and a senior barrister on the other side. The only reason why it stopped was because the Human Rights Commissioner, for that case, the President of the Human Rights Commission, Ron Wilson, who was somebody I've got immense respect for, he actually called the lawyers together and said to them, you can proceed with all this statistical evidence from both sides if you wish. I can't guarantee at the end of it all whether I understand any of it. Do you really want to proceed? And the lawyers looked at each other and said, no. It was fascinating. We've also done, over the years, lots and lots of liquor licensing surveys in various jurisdictions. I'll come back and reference some of that later on. Another set of cases that we've worked with is in this personal injury area. I'll just touch upon a couple of these ones. But this sort of shows the diversity of the work that happens here and the way you never know quite how it's going to develop. I was actually contacted by some lawyers who were acting for an insurance company who was handling a case of what was really a very, very sad case. It was a genetic defect in a young child. It could have been possibly, maybe should have been, picked up during pregnancy, so some action could possibly have been taken. For those who know about the genetic side of it, it's what's called the Pallister-Killian syndrome, and it's a mosaic thing where there's a genetic defect that doesn't show itself up in every single cell. So things like Down syndrome, it's a genetic defect which is uniformly in every cell in the body. This one doesn't always show up. But the consequences are absolutely terrible. Now, amniocentesis test can, in theory, has got a chance of showing it up. But this one, and in this case here, the test that had been carried out wasn't carried out quite properly. So it's a small issue. Effectively, there should have been 4 slides of culture prepared. There was only 3 that were usable, and there was a couple of other small details which were a bit wrong. So the plaintiff, in this case, said, well, this was not picked up because the test wasn't done properly. I got involved because the plaintiff's side actually, in this case, did have a statistician involved who actually produced a whole lot of calculations, probability calculations about this. There were probability calculations that I thought were quite wrong, as it turned out. There's a lot of detail that was not handled there. So there was a lot of experts in this particular one. I was working very closely with pathologists, geneticists, and the statistician on the other side. It was interesting there for the statistician, because the statistician was the one who was really quantifying the risks. Yeah? Because at the end of the day, what the court wanted to know, to what extent did this improper conduct of the test lead to an increase in the risks. So it was a quantification. So the statistician was right in the middle. And this was actually meant that I was forced to actually collect, or have collected, a whole lot more data for this. The way these tests are carried out, there's a culture, the material from the amniocentesis, the amniotic fluid, is put out onto slides which are cultured. Colonies form around the individual cells from the sample of amniotic fluid. For each colony, you can actually then sort of see how they're developing. And when cells are in the metaphase and they're undergoing division, then you can see the chromosomes. So it's awful data to work with because you've got these different colonies which overlap each other. This is a typical example of what they might look like there. Overlapping colonies. Sort of each colony comes from a single cell, but you don't know quite where the boundaries are. Some of the colonies don't display this mosaicism at all. Some partially display it, some fully display it. The probability model for that is horrendous. And just trying to work out what the probability of detecting this condition for which the test was never designed, and how that probability was altered by the test not being carried out quite properly. So we actually had to go and collect a whole lot of data. We actually went back to those slides and we actually counted every single cell. Normally only 15 cells we looked at. We had to look at every single one so we could actually get the population. And then you could actually go through and work out what some of the sampling statistics were and modelling that. So this was an interesting one as a statistician where you really had to actually go beyond the data that was already there, and to really answer the question properly, you actually had to say, well, we need a whole lot more data. And I was lucky in that case that the lawyers sort of said, not straight away, but they said, yes, we can do it, we'll fund that. They didn't fund me for very much more, but they funded a pathologist to actually go through and do all this incredibly detailed manual work collecting this data. So lawyers are often sort of looking at the costs in doing this. Even though people criticise lawyers a lot, in my experience, they are always actually very good at looking after their clients' interests. And that includes all the financial calculations there. Because at the end of this, the lawyer could have said, sorry, the client could have said, it's not worth pursuing this matter. It's going to cost that much to get the data. I would rather just pay up. Other personal injury cases. These are fun ones. Statistics is fun. People falling off a trampoline and becoming a paraplegic, which is not so much fun. There. That's another one we've worked on recently. And there it's an issue of just the quality of data that's being presented by the other side. The likelihood of two racehorses colliding with each other in training. Again, it's a personal injury matter. Why are there so many of these personal injury matters? Well, quite simply because there's big money involved. These are individually worth many millions of dollars. And they're being fought over quite hard because of that. And it takes a little bit of, how would I put it? You have to be a bit detached from this because, you know, every one of these cases there is a very, very sad situation behind it. Smoking. Smoking was a personal injury matter as well, because it's handled much the same way. There. I said earlier on that I accept any job that comes to me if I can do it. If I can do it. So that when I actually did have the lawyers for a tobacco company coming to see me, now, I told them, amongst other things, well, I didn't have much time for tobacco companies. Tobacco or smoking had definitely contributed to my father's death, things like that. But I'll give them my best run. And that's the job of the statistician. So, this was not a question about whether smoking incidentally causes lung cancer. That was decided a long time ago. Nobody argues over that anymore, at least not in Australia. But these matters come up because there's money involved, big money. And somebody says, well, yes, this person died from, is dying of lung cancer. Whose cigarette killed him? And it sounds ridiculous, but that's what the argument comes down to in some cases. And it's a valid argument to be worked through. For this first case, there's only a couple of matters where I actually worked on smoking, because they seem to have disappeared. They're handled somehow these days, which is good because it means that the court process has sorted out the right way of doing it now. But the first one, I remember going through it, and we actually accessed a large data set from a prospective study in the US, which followed a number of people over the years, and something like a cohort of about 1 million people or something, and then looked at how those people who got lung cancer. And you can actually fit some quite good models to that data. Some people had already fitted models. We looked at some of their models, fitted our own models for comparison purposes, and saw what those models predicted. And that was an interesting matter for that one, because at the end of it, I sort of said words to the effect of, well, there's something like a 55% chance that, you know, it was your cigarette that killed her. And the barrister, the barrister said to me, it would have been nice if it was less than 50%. But absolutely no pressure on me to change my work at all. Absolutely none. Because I was the expert, and that's accepted by this legal fraternity. So there are a couple of cases that I did like that. And as I say, I personally found it confronting because smoking had probably contributed to my father's death. Another personal injury matter here was very, very different. And again, this is, I think, the last example that I'm talking about, as where I was appearing in a like this. This was a plane crash, a light plane. And the question came up, had the pilot actually done the right thing? And in this particular case, there was an issue of, had he actually turned the plane too sharply? This was not to be honest, I felt that this was a more problematic case than the smoking one, to be honest, because what we were looking at there was, you know, the pilot being blamed for this crash. If he hadn't been a good pilot, the plane would have actually crashed and killed all of the passengers, to be honest. As it was, he almost got it to land. One passenger was killed, and the pilot was sort of had 80% burns over his body. And now he was being blamed for it. These are terrible matters sometimes. What we had were a sequence of radar data saying this is where the plane was, that every few seconds. So you had a radar that was rotating and there, which was some kilometres away from the airport where all this occurred. And it was actually saying, yes, the plane is here, it is here, it is here. And there's a certain error in that there. There's a different error in the distance and in the direction there. Now, statistically, this wasn't a very difficult problem, as it turned out. The reason why they got me involved was because they actually had seen that the report from the other side just used some black box program that flight investigators use. What was in the program? Well, nobody knew. But it just gave out answers. But they wanted somebody who could actually say, well, is this reasonable or not? Now, statistically, it wasn't all that hard a problem, to be honest. The way I approached it was actually very simple, that even though this was the original data was had these ellipsoids of uncertainty there, which were at an angle, and that angle corresponded to the direction of the radar system from this area. Simply by rotating my coordinates and getting it so they're oriented with the axes, suddenly you could reduce the problem down from being this two-dimensional problem down to being two single-dimensional problems. Fit splines, so you actually get the position as the x and y coordinates as a function of time. So you get a spline. Rotate back to your standard coordinates. And then just use a bit of differential geometry, which I don't believe students get taught anymore, are they? But, That's good to hear. That's good to hear, because I can remember doing it as an undergraduate, and then I must say that nothing I ever did as an undergraduate has not been used at some stage. So this was then. So this was an interesting problem because and one of the issues there was, well, was this really statistics or mathematics? Well, to me, I don't really care. To me, Statistics is part of mathematics. It was within my mathematical ability to do this. And none of these problems that you get actually tend to be nice and following boundaries. If you're getting involved as an expert, you will find yourself always stretched. And you have to keep asking yourself, well, am I able to do this next bit? And the answer is often yes, perhaps not with as much comfort as some other bits. But if you want to solve the whole problem, often you have to really stretch yourself a bit. So I thought I was competent to do this. It could be something that could then be tested in court. As it turned out, this matter got settled by other means. There. Was my analysis useful? Well, I think so, yes. So I think I did a good job as an expert on that one. There's another area here where the role is, it's very interesting for a statistician there. A surprising amount of expert evidence is statistical in its nature. Medical malpractice or personal injury matters are full of statistics. You know, what is the probability of somebody falling off a motorbike? What is the increased risk of a crash or an injury if speed limits are changed and things like that? These are constantly statistical things there. And very often, this very statistical evidence is being presented by people like rank amateurs in court. They might be experts at road safety, experts at some aspects of medicine, but they're often rank amateurs at statistics. So I've often been brought in to, depending upon which side I'm on relative to that expert, either to pull them to pieces or to support them, to help them build up the case, or to make sure it's right, more to the point. There. And one thing I've really noticed that comes through with this is that very often that lack of understanding of statistics means that there's a natural inclination for them to interpret the uncertainties in their work in a particular direction. So I think, quite honestly, this lack of statistics in the lack of statistical ability in many of these so-called experts is leading to quite serious biases. Okay, I mentioned earlier on that I'd done some liquor licensing work. I was going to refer to it. So I'll give an example here of some of these, what I think are some, I hesitate to use the word biases because I think that, I don't think that in any sense they're conscious at all here, but this is an area which is, where there's a lot of statistical evidence that I have seen in court that I've got grave reservations about. And this is a simple issue in one sense. If you get more liquor outlets, will there be more harm in the community? Now, this is a simple question to ask. It sounds plausible to some extent. So there is some theory, some causal theory, some sociologist theory that says if you've got more liquor outlets, then that means that liquor is more accessible, therefore more people will buy it, or people will buy more of it. Therefore there will be more liquor consumed, so therefore there will be more harm. But does it really happen as simple as that? Is it as simple as that? So you've really got to go and look at the empirical evidence. And this evidence is all heavily statistical. There are many studies of this. There have been studies in Australia. There have been a number of studies in Melbourne, in fact. And they're almost always using some variation on a theme of spatial and sometimes temporal associations between harm and sale of alcohol. Either places where you can buy alcohol or volumes sold or something like that. There. This is very difficult data to work with. Very, very difficult, because it's a very indirect association. Because you can hardly ever say, because this person bought this bottle of alcohol at this place, something happened. That's a very rare occurrence, that you can actually have any meaningful link like that. So it's all statistical. But it is very difficult statistics. There's a lot of observation. For a start, these studies are all observational or not. You can't go around and say, okay, we'll have a random assignment of treatments, we will now give sort of Q an extra 3 liquor outlets. We'll take several away from this other suburb over here, and we'll randomly do this, in some sense, across Melbourne. You can't do a design study like that. These are all observational studies, which means that you never know, or you might never know, it's difficult to know, whether, for example, the liquor outlets follow consumption or consumption follows the liquor outlets. There are issues of, in terms of what topology do you use if you're looking at this. Do you look at how people are, how close people are by as the crow flies, along the streets, time, consider different modes of travelling? There are stacks and stacks of things. There are lots of covariates involved there. Covariates is an interesting one because a case I was involved with in Western Australia, there was a public, there was a lot of publicity on a paper that was produced at University of Western Australia. There was actually a number of authors, but the lead author was UWA. And they said that living near a liquor outlet is bad for your mental health. Now, they actually have found an association there, a correlation. And while I've honestly got some reservations about the quality of the analysis in that case, if we assume that that correlation is statistically significant and true, it's a correlation. But you'll also find that, and this is some work that I did with, if you look at other things as well. Because if there is a liquor outlet there, that's, okay, it's probably in a shopping centre, so there's probably a hairdresser. So I could show that if you look at various other sorts of outlets as well, they were probably also likely to have this mental health issue as well. So living too close to a women's hairdresser is probably bad for you. But it's something about the quality of the work that has been done there. Because ultimately there are all these regression problems, regression models are fitted to data like this, and it's very, very complex. The data is often relatively sparse, because if you look, these measurements of harm are often cases like assaults or something like that. There aren't very many of them, to be honest. There aren't enough of them for a statistician. And often they lead to really what are second-rate models being fitted. And a typical quote from one of these papers that is referred to a lot says something like, and I'm just paraphrasing here, adding another outlet will increase violent assaults by, shall we say, 13%. And that statement is made irrespective of how many outlets are already there, irrespective of how many assaults are already occurring, and irrespective of the area that you're looking at. Now, this just doesn't make logical sense. But these models are being promoted there. Now, finally, I said there is a suspicion that the models are not always chosen objectively. There's very few cases you can pin this down. But there's one very prominent paper that's often referred to where the author or the authors came up with two models in the end, one of which they demonstrated fitted better than the other. The model which fitted better said, in a sense, there was no association between liquor outlets and harm, and the one that didn't fit as well was a simpler model, said there was an association. So in their conclusions, they only referred to the first model. There was a clear bias in selection there. I don't think a good statistician would make that sort of mistake. How do we try to pursue this one? Well, this expression, show me the evidence. I wish that Terry Speed could have been here tonight. He apologised, but he couldn't be. But I remember him giving an absolutely amazingly great talk at a graduation ceremony at UWA about 10 years ago when he was getting an honorary degree there. And his message to the graduands, people who were graduating that night, was, whenever you go through life, always demand to see the evidence. So show me the evidence was his motto in life, and he's trying to express this to lots of people there. So I actually sort of said to these, for one of these studies, could they just show me the evidence? And I politely asked them, wrote them saying, I am working for so-and-so, didn't want to hide anything, can I see the data? No reply. Got the lawyers to ask. They said no. We actually subpoenaed the data. This is the legal process for that. Now, researchers often tend to guard their data, but so they put a lot of work into it, and I can understand that. And often there are confidentiality issues and all of that sort of thing. And that is absolutely valid concerns. But courts regularly handle situations like this. Courts regularly handle commercial disputes where there is very sensitive financial data that has to be looked at by experts. So this is not really a big issue. I am really very sad that in this particular case, the other side said, well, if you're demanding to see the data and we can't stop you from looking at it, then we'll simply withdraw all the evidence. They did not want to present it. They no longer referred to that research work. Which that left me feeling a bit sort of, well, I was disappointed, to put it politely. Yeah. So I don't know whether that's a reasonable response on their part. So to some extent in that case, I think it was the statistician's role was to keep the bastards honest, to paraphrase yet another Melbourne person. I think Don Ship was Melbourne? Don Ship, yes, he was Melbourne, wasn't he? Yes, okay, yes. So I honestly think that in this regard, statisticians have got a training which actually makes them very suited to this sort of work because, to be honest, in my experience working in court, the statisticians have often got the highest standards, with one exception, and that is that sometimes you find people who get involved in an advocacy role as well. And that's very, very hard to sort of be a scientist or be objective and have an advocacy role at the same time. But statisticians should be involved in this work because these questions are actually very important for society. And it's not just in court for this. So that with what I talked about here, well, for a start, anything that gets sorted out in legal cases leads to precedents and often to either changes in the way the law works or to changes in the law itself. So the liquor licensing is a classic issue where there's a constant discussion about whether the law on licensing should be changed. And I think it's very important that statisticians be involved in this, and to be honest, that the other researchers in that area also contribute in a very open and honest fashion. This issue I talked about this density and various forms of harm, I honestly wish that was sorted out. It needs statisticians to be allowed to be involved there. And to be honest, it doesn't have to be happening in court for that to work. So, to summarise, and I've gone a bit over time, I'm afraid. Sorry about that. So I think the work of the expert in this way is actually quite important in our society. This is one way in which statisticians can and should be contributing because there's an awful lot of statistical work that is going on in the courts. So you have to get involved. And that often means convincing non-statisticians about this. And the last thing is that it's actually surprisingly good to work with lawyers. I enjoy it. I don't think I'm too weird when I say that. Because what do lawyers do? Well, they collect evidence. We collect data. They analyse it or review it the same way that we do. They evaluate the quality of the data. They fit models that combine the data in different ways, evidence, and they make inferences from it. So really what lawyers do and what we do is surprisingly similar. You should think that we've got a lot in common. We should be talking to each other all the time. It doesn't happen. Lawyers are often very good at talking about, in very precise ways, about very imprecise concepts, words. We are often talking in perhaps less precise ways, but about much more precise things in some cases. However, I personally feel that there is sufficient overlap that if you try, there's a lot to talk about because there's a lot in common. And as I say, it's important for our society that we do it. Thank you.
Questions from the audience?
Yes?
So my question is about talking in precise ways about very precise concepts. There are some concepts in statistics that are very close but sort of quite different, like alpha levels and p-values and false discovery rates. subtleties in statistics where, in some sense, like a lot of practitioners make mistakes. In some sense, you almost have to know both concepts to really understand the distinction.
Okay, well, the first issue is trying to avoid those problems in the first place. I suppose I'm a somewhat pragmatic person who thinks that if your final findings are heavily dependent or heavily sensitive to some assumptions which are really a bit esoteric, to be honest, in many cases, then that really means that they're borderline. So that ideally you should be avoiding those. And in fact, in general, if things are borderline, then the lawyers themselves will probably be backing off from presenting evidence of that nature, because they know that it's weak. So in some respects, those problems don't come up very often. I won't say they never come up. The case I mentioned where I was cross-examined for 4 days, probably about 1 day of that related to how do you calculate a p-value for a 2x2 contingency table. Okay? And I think I was right in what I was saying. Other people might disagree. But the issue there was one of, you know, where this problem of words being used in very imprecise ways was a real problem, because people, as one side was saying, well, we have used Fisher's exact test. Now, that's a great name for a test. You know, it could have been called, you know, Fisher's absolutely optimal, wonderful test that solves all your problems. Or something like that, because the name itself says everything, doesn't it? But it's a test that involves a calculation of an exact probability subject to certain assumptions. So it's exact in one sense, but that exactness is something which is really quite specific and possibly irrelevant and possibly based upon incorrect assumptions for some contexts, in fact, for many contexts. There. Now, that was the one where, at the end of the day, Ron Wilson, the President of the Human Rights Commission, said, more or less, you know, I'm giving up on this one, which I think was an understandable call on his part. I don't think that many other judges would have actually admitted their own fallibility in quite the same way. But he was a special person.
Thank you. Another question?
What's the role of a statistician if you give your testimony and then it turns out later what you said was wrong? So the example I'm thinking of is when a woman was convicted of murdering her babies because they thought that the condition that the babies had at children was independent. So it was very unlikely that two died at the same family.
Yes, yes.
But later they found out that it was actually a kid from the family, so if you had it happen once, it's more likely to happen the second.
Yeah. I think the cases you're talking about, is it the Sally Clark case?
Yes, Sid's case,
yeah. Yeah, in the UK, which is Sid's case, where that was a classic example. So thank you for raising this. That's a classic example where you had a non-statistician presenting statistical evidence. In that case, it was a paediatrician who said, well, the probability of having a SIDS death was X, and hence he said, well, the probability of having two of them is X, was that amount squared, three of them, that amount cubed, which is why he then came up with a statement saying having one such case is sad, two is suspicious, three is murder. That's effectively his words. But he was a non-statistician, and that's a classic case where statisticians then did step in. So there was an appeal against that. There was a public letter by the President of the Royal Statistical Society, public letter to the Home Secretary or something like that. I'm not quite sure quite the legal positions in the UK for doing that. But statisticians are actually very active in getting that case overturned. So that's exactly shows my point, that why we have to be there in the first place, so that nonsense doesn't go on. And that was a very sad case because that particular woman, eventually she drank herself to death. She had been treated so badly through that one. You know, there are still victims to that.
Right up the back. Speak louder.
Yes?
say, oh, you disagree with that calculations, you think it's wrong. I'm just thinking it's probably fair to our profession to just disagree, say, they're wrong. But what would be your approach? Would you try to reach some agreement with the opposing statistician, or would you just say, oh, your assumptions are wrong?
Well, okay. I have been in that situation several times. The human rights case one, the statistician on the other side is somebody I had known for many years, in fact. That case went very badly, I think, for everybody concerned, because in that case the lawyers had such tight control over it that they did not want to conciliate at all. That was an unfortunate situation there. And there were some other issues there as well. In some other cases I've been involved, you get this exchange of documents, and eventually, often you move towards at least partial agreement. But that's also why there is this provision, I think virtually in all jurisdictions these days, that the court can insist that the experts from the opposing sides get together. And that's why the experts, in getting together, they should be under no constraints. The person who is paying them can't say, we won't let you, we don't want you to agree with the other side. If it's a technical agreement on the area of expertise, after discussion you agree, you should say you agree, and that's it. So I think the courts themselves have actually got that reasonably under control, or they have the mechanisms for getting it under control. It doesn't always work, but... and at the end of the day, if, as I think the way you described the situation, it might be that you're making different assumptions. If those assumptions are detailed well enough, and then that can be explained to the lawyers involved, and in their summing up, they will be saying something like, that we assume this, the other side assumes that, and there'll be arguments as to why you might assume those different things. So it's not as serious a problem as you might first think. And as a profession, I would think that it's better for us to be involved there, even if we do have some arguments, including some arguments in public, rather than not being involved at all.
A couple more questions.
Yeah, I think you might have already answered partially. My question is, how does one justify that statistical assumption in court? So it seems every assumption can be questioned. How does one actually justify statistical assumption in court situation?
That's not necessarily very different from many other contexts where you might, for example, just look at the data and say, does this assumption look consistent with the data, or something like that. So that's quite a common situation. There is one respect in which an expert in court has actually got an advantage over experts out of court, in that the court assumes, until proven otherwise, that the expert is an expert. And that means that the expert could often say, well, in my judgment, in my experience. Now that goes against the grain to some extent as a statistician. We're taught to actually question all these things, being very, very careful and going into the detail. But then you go to court and you suddenly realise that all these other experts there in other areas, engineers will say, oh yeah, that's the way you build a bridge. In my experience, I think, in my judgment, that's good. A town planner will say, well, this proposed development here, to me, it's bad planning. They all make these judgments, these statements, on a regular basis. And the court will actually judge those statements in terms of the degree to which they believe that expert really is an expert. So in some respects, it's easier in the court context there. Whether it should be, I'm not sure always, because some of these other experts I've got my worries about.
Last question from you.
You're an accredited statistician in the Statistical Society of Australia.
Yes?
Have you found lawyers interested in experts giving statistical material who lack that accreditation? This is the lack of an accreditation status had any mileage in any cases that you've been involved in?
I wish I could say yes. Okay, I wish I'd say yes. Because I'm an accredited statistician. I chaired the accreditation committee for a number of years. I think the accreditation process of the Statistical Society is very important there. And I make sure that if I'm putting in a statement that actually says there that, you know, I'm accredited, so that when I sign off a legal statement, I've always got there at the end, you know, Dr. John Henstridge. I put in, you know, A stat, C stat, and a few other odds and sods for there, my accreditation there. It should be important. I think it is regarded by some people as important, but there are exceptions. I've been in situations which are downright embarrassing, where you get somebody on the other side who is an amateur at statistics, who has quite simply misunderstood basic things. These are the things you try to knock out of students in their first year. And it gets very embarrassing, where you've actually, well, I've had to say at one stage in a tribunal, look, Your Honour, what X is saying, it's a mistake made by undergraduates, but it should not be made here. It is so fundamental, so obviously wrong, that I almost don't know where to start, you know, describing how it is wrong. This is issues like saying that testing for a difference is equivalent to saying that the two confidence intervals do or don't overlap. Something fundamentally wrong there. So in that case, it was difficult to get an argument across, even though, you know, I had 30 years experience as a statistician, or some big number, and this is some little pup. Okay? I didn't use those words in the tribunal, but that was it. So, yes. So that's an answer. Yes, it's important, but it should be more important.
Well, on that note, I'd like to make one observation, that is that during our correspondence on email, John said that he hoped that he would do Maurice Belz proud. I feel he's done that tonight, so join me in thanking